Good afternoon, everybody. Just bear with us for 20 to 30 seconds, if you would. We have over 400 registrations for this webinar, so I'm just going to wait to let the attendees in. So please bear with us. Thank you. The numbers continue to rise, but I will get us going as I'm conscious of everybody's time. Good afternoon to all, and a very warm welcome to the next IFA 60-minute webinar. I do hope everybody's keeping well, and I'm glad to see already that people are using the chat and the Q&A facility. I'll come on to that in a moment. Can I welcome this afternoon's speaker, Ewan Lawrence. Ewan, welcome, and welcome back in many respects, because you've kindly given the employment law updates to the Institute's members previously. But I think, as your summary notes put it, probably 2 years on from the first lockdown that the UK went into, much has changed in the world of employment law. And I think it's important that both employers, practitioners understand what's happening and what's occurring. So thank you for joining us. As an introduction for all those who haven't heard Ewan before, Ewan Lawrence is a solicitor partner in the employment team at Blacks Solicitors. Ewan specialises in a number of areas of employment law, advising both employers and individual employees. Particular areas of focus include drafting and negotiating settlement agreements, directors' service agreements, and other related employment documentation, advising on 2P transfers, and contesting claims in the employment tribunal. So Ewan, welcome, and thank you very much for your time this afternoon. Before I hand over, can I just remind everybody of some housekeeping points? Please, if you have questions, and I very much hope people do, if you have questions, observations, experiences, please use the Q&A or the chat box facility. I note already that a good number of you are saying hello to each other using the chat facility, so you know what to use and you know how to use it. But your questions along the way, please, they are what bring these sessions to life. And it also helps somebody like you and understand which areas are really pertinent and important for members. So please post those. Where something's pertinent and probably quite important, I will interject and I'll ask those questions of you. And if not, I'll save certain things up for the end. If you have any technical issues, please check your own connectivity and Wi-Fi. If we have any wider technology issues, we will look to resolve those as efficiently and as quickly as possible. But enough from me, because I know Ewan has a lot to get through this afternoon. Ewan, welcome. Thank you very much indeed. And the floor is yours. I will disappear into the background, but look forward to coming back and forth with questions. Thank you.
Thanks very much indeed, Jonathan, and good afternoon, everybody. Thank you very much for the Institute of Financial Accountants for the opportunity to speak to you today. And thanks to all of you who've dialed in to watch. Just to add to what Jonathan has said, absolutely please do put your questions in the chat and in the Q&A function, and where I can't deal with those contemporaneously, there's going to be opportunity at the end for me to pick those up. In addition, copies of my slides will be sent to all the delegates after this session has ended, which I know is a very common question to be asked. So today's webinar is broadly in two parts. The first catches you up on developments in employment law in 2021, and the second sets out what has and what we anticipate will happen in 2022. So Let's start with what I'm pretty certain has been the most widely discussed facet of UK employment law over the last 2 years, the coronavirus job protection scheme. This commenced in March 2020, if you can remember back then, close to the start of the pandemic, and it's estimated that around 11.6 million jobs were supported. Now, whilst it is more than a little amusing to think that it fell to a Conservative Chancellor to introduce measures that seem to be taken from a socialist utopian playbook, if only for a temporary period, and whilst there will inevitably have been individuals who fell through the net and didn't benefit from the support, it is difficult to argue that the furlough scheme was not, for the most part, a success. For example, according to the BBC, anticipated job losses more than halved from the 1 in 10 predicted at the start of the pandemic to now less than 1 in 20. The scheme cost an estimated £70 billion, which represented around a fifth of the total money spent by the government in response to COVID. Although hailed by some as the current government's biggest success, the scheme was very far from perfect. The guidance was initially somewhat vague and in parts inconsistent, and rule changes were generally issued late on a Friday, which led to a frantic rush for lawyers and HR advisors to get up to speed in order to be able to advise clients. It is also fair to say that a material number of employers took unfair advantage of the scheme and the broad way in which the rules were set out. And furlough fraud is thought to have cost the government more than £7 billion. As I say, the jury's out on exactly how successful the scheme was and whether it could have been even more effective. What also remains to be seen is how strict HMRC are likely to be when it comes to their investigations into employers who have inadvertently committed technical breaches of the rules and claimed more than they should, or claimed in circumstances where they were not entitled to. The indication so far is that HMRC are most interested in pursuing the really egregious deliberate offenders, and there's enough of those at the moment, rather than hauling employers who made innocent mistakes over the coals. But that may well change as the pressure increases on the Treasury to balance the books. Next up, we have the topic that was, prior to the pandemic, probably the biggest event of many of our lifetimes, but which now seems like comparatively small beer. I refer, of course, to Brexit. At this point, I should stress that I'm not an immigration law specialist, so this is necessarily a broad brush overview. Now, as you will recall, the UK left the EU on 31st of January 2020. Transition period ended on 31st December 2020, and so the new immigration rules started on the 1st of January of last year. As a result of the changes, the EU freedom of movement rules, which formally applied within the UK, ended on the 1st of January last year, meaning that anyone from outside the UK, including EU workers, required a visa to work, and employers also needed to hold a sponsor license to be able to sponsor employees to work in the UK. From that date, anyone coming to work in the UK must meet the skill and salary criteria as laid out by the government. They must speak English, and they must have a job offer from an employer who is a licensed sponsor. Any EU citizen who arrived in the UK before the 31st December 2020 had until the 30th of June last year to make an application under the EU settlement scheme to keep the right to live and work in this country. International companies can still go ahead with temporary intra-company transfers, but again, that's subject to the company's intra-company transfer criteria being met. And if employers are or intend to recruit from overseas, they should really familiarise themselves with their duties as a sponsor and apply for a sponsor licence. Training should also be undertaken by any staff who recruit and have responsibility for ensuring that the business complies with its duties as a sponsor. Now, back onto employment law arising from, employment law issues, I should say, arising from the pandemic. We had a potentially significant legislative change relating to Section 44 of the Employment Rights Act 1996. Now, by way of a quick reminder, prior to May of last year, Section 44, and for that matter, Section 100 of the Act, protected employees from being subject to retaliatory measures from their employer in circumstances where they took steps relating to health and safety in the workplace. Most notably, notifying their employer of a health and safety risk, dealing with the health and safety risk, and or, probably most pertinently over the last couple of years, leaving work or refusing to return to work because of a reasonably perceived health and safety risk. Now, inevitably, with the separate waves of lockdown and the large number of employers who had to navigate their way through trying to make their workplaces safe for employees to return to, there was a much more significant focus on Section 44 among employees, employers, and in particular those who advised them. The fact that this protection under Section 44 and 100 was only afforded to employees and not workers was what led to the case of the Independent Workers' Union of Great Britain against the Secretary of State for Work and Pensions and others. So the background to this was that in 2020, following the start of the pandemic, the union received a vast amount of questions from its members, most of whom work in the gig economy, relating to their exposure to the virus because of, respectively, inadequacy of the PPE equipment provided to them, the failure to implement social distancing in their workplaces, and other issues of a similar nature. And the union argued that not extending the protection afforded by Section 44 to workers as well as employees actually contravened two separate European Council directives. As a result of this landmark case, the government amended Section 44 to extend the health and safety protection to workers as well as to employees. And to be blunt, there is a certain logic to this move, given that, for example, Section 43K of the same Act already extends whistleblowing protection to workers in addition to employees. And it would seem very peculiar if a worker making health and safety disclosures that could constitute whistleblowing or a disclosure of the type referred to as Section 44 will be protected as a whistleblower, but not under Section 44. So this case has resolved that issue. Now we next move on to look at developments in discrimination law relating to the menopause. This is clearly a very significant issue in the workplace. For example, the UK financial services industry commissioned a report which found that women who are suffering with menopausal symptoms are tending to avoid applying for promotions, and some are leaving the industry that they work in altogether. Now, whilst the menopause itself is not a deemed disability as such, and does not always have debilitating symptoms, some of the symptoms, which include palpitations, joint stiffness, recurrent urinary tract infections, and difficulty concentrating, could well be defined as a disability for the purposes of the Equality Act. And as a quick reminder, to be a disability for the purpose of the Act, a condition must constitute a physical or mental impairment which has a substantial and long-term effect on the person's ability to conduct day-to-day activities. So whether menopausal symptoms constitute a disability will depend on how long they last and the impact that they have on the employee. Now, not only do women have to deal with the symptoms of the menopause, the stigma attached to menopause can also permeate workplace culture, meaning it's often difficult to bring up the subject with the employer, which in turn means most women often opt to suffer in silence. Or at least they did. Because whilst this has clearly been an issue in the workplace for a long time, actually the risks to employers who ignore this are increasing, as it appears to be something of a growth area for tribunal litigation. In 2018, only 5 tribunal claims referenced the menopause, but by 2020, this had increased to 16. This risk has been attributable to the female workforce becoming more and more conscious than ever of their employment law rights, and quite right too. In the recent case of Donachie against Talent Technology Services, the Employment Tribunal found that the claimant's menopausal symptoms, being hot flushes and night sweats up to 8 times per day, did amount to a disability, but equally, there are other cases where the findings have gone the other way. And this simply demonstrates that these cases are very fact-sensitive, and menopausal symptoms will not automatically amount to a disability, but sometimes they will. If employers have staff who are suffering from the menopause, it's important that they're flexible with these employees and consider any adjustments which would make their work life easier. They should also ensure that their work environment is optimized to help ease symptoms. This is likely to make affected employees work more effectively and feel that they're being supported by their employer. It's also wise to take care not to make presumptions about symptoms of ill health being related to menopause, as this could constitute unlawful harassment. Now, in relation to employment documentation and where that comes in, whilst it's perhaps a knee-jerk response of employment lawyers, such as myself and HR professionals alike, to try and address an issue like this through a jolly good workplace policy, provided that this policy doesn't represent the beginning, middle and end of an employer's consideration of the issue, can be no bad thing as far as I'm concerned, particularly if it encourages employees to be able to speak about this without fear of stigma. And finally, it's also worth bearing in mind that the duty of care in relation to health and safety does have a bearing, and employers need to ensure that their risk assessments include any specific risks to employees going through the menopause. Now, over the last 24 months, we have seen two separate stay-at-home orders where the UK population were only permitted to leave their home for certain reasons. And as a result of this, many of us were told to work from home. As lockdown eased, many employers decided to continue to allow or even directed their employees to work from home for at least some of their normal working week. And this has represented a sea change for many organisations. To take my own firm as an example, prior to the pandemic, I had a workforce of approaching 200. I could probably count on the fingers of one hand the number of employees who regularly worked from home. Now, having recognised the advantages to both employee and employer, we've merged our two physical offices and encourage a default hybrid working pattern of 3 days in the office and 2 days from home each week. And I think we're probably fairly typical when it comes to firms, particularly professional services firms. Recent studies have found that one of the main reasons employees are attracted to hybrid working is having a better work-life balance. They can work at times when they're more productive, whether this be in the morning or evening, rather than having to attend their offices for their entire normal working hours. The study also said that 66% of employees say that they're worried about their health and safety. By working from home, they're reducing their exposure to illnesses. Employers may want to opt to implement a hybrid working model so they can reduce the amount of office space that's needed, as indeed we did, and thereby reducing the costs on office space potentially significantly. By law, employers have to undertake an appropriate risk assessment of their employees' working environment. Now, if they are unable to carry out a full risk assessment, for example, because the employee is working from home, then the appropriate information should be provided to the employee to ensure that they are working safely. And any risk assessment should be reviewed regularly to maintain that safe working environment month by month and year by year. Attention should also be paid to employees' mental health. Now, while some employees may enjoy working from home, for others, it can be very lonely and isolating. Employers should really make sure that they speak with their employees and support them in any way they reasonably can. Again, relevant policies can and probably should be introduced and are updated in line with hybrid working models, together with putting in place appropriate measures aimed at ensuring the employer's data and systems are secure, which is, of course, vital in relation to, for example, client and customer data and confidential information. Employers may be worried that their employees' level of productivity may suffer if they work from home. And certainly this is something which a lot of employers have been wrestling with over the last 2 years. Now, although employers aren't able to monitor every single aspect of their employees' work when working from home, there are measures that they could introduce. For example, implementing regular one-to-ones or introducing key performance measures. Now, just to quickly address a few relatively important and or interesting cases that came up last year. Firstly, the case of Bayfield against Wunderman. This was where an advertising agency tried to reduce their gender pay gap and step away from their reputation as a Knightsbridge boys club, which you might think that's a very admirable and laudable aim. But the steps that they took were fairly extreme. They simply fired 2 of their male directors. And these 2 directors issued a wide range of claims and succeeded in claims for direct sex discrimination, victimization, and unfair dismissal. Now, Wunderman has since tweeted that they are going to be appealing the decision to the EAT, but this is, I think, a useful warning to employers when considering how they intend to reduce the gender pay gap in their organizations, to think twice before jumping straight to the nuclear option of sacking particular members of staff from a certain gender. Now, the next case, that of LA UK against Gellin, this relates to what's known as the reasonable steps defence, which is available to most kinds of discrimination claims, where you can as the employer, if you can demonstrate that you took all reasonable steps from preventing the person who committed the act of discrimination from doing that thing or a thing like it, then you have a defence from being vicariously liable for that act. Now, in this case, the claimant was dismissed by the respondent due to his performance, then went on to raise an internal claim of racial harassment by a colleague. And following an internal investigation, it was found that the claims were made out. And the respondent responded to these internal complaints by making the employee in question undertake further equality and diversity training. And when the claimant then issued his claims at the employment tribunal, the respondent sought to use this reasonable steps defence, saying, well, we couldn't have done any more. We've given equality and diversity training. What do you want? And the EAT found that the employer could not rely on this defence, as the training received was clearly stale and all reasonable steps had not been taken to avoid discrimination in the workplace. There were many other reasonable and continuing steps that the company could have taken than just providing one round of training or having an equal opportunities policy. Refresher training being an obvious example. Now, as an aside on this point, at a preliminary hearing I attended last year, the judge in that case commented that he'd never actually seen the reasonable steps defence succeed in practice, which just demonstrates what a high bar mark there is for that. Then the case of Asda Stores against Brearley. This is a long-running equal pay claim which occasionally comes into the news. At this stage, the Supreme Court ruled that Asda workers who are based in the supermarket can compare themselves to workers who are based at the warehouse depot. Now, whilst this doesn't actually settle the substance of the claims, it does resolve the issue of who the appropriate comparators are. And the Supreme Court, when making the judgment, specifically advised the employment tribunal not to overcomplicate any assessment and to try and avoid any further appeals. Because again, as an aside, from a very cynical perspective, it does quite suit Asda and other large employers to keep these claims from being decided for as long as possible by continuing appealing decisions on technical issues as far up the appellate court structure as possible. Now, the next case, Uber, you're probably all very well aware of. This was a highly awaited judgment which did finally confirm that Uber drivers are entitled to receive national minimum wage and paid annual leave. And the judgment does serve to place some limits on the flexibility of employers in the gig economy and introduce some safeguards. Now, the Maya Forstater case you might not be as familiar with. In this case involving the non-renewal of the claimant's contract, allegedly because of tweets that she had made, which colleagues considered to be transphobic, exclusionary or offensive. The Employment Appeal Tribunal, overturning the decision of the tribunal at first instance, found that the claimant's, quote, gender critical beliefs that, for example, sex is fixed and should not be conflated with gender identity, did qualify for protection under the Equality Act as philosophical beliefs. Now, given the amount of coverage these particular issues seem to have on Twitter, it would surprise me greatly if this was the last case in which a claimant tried to rely on having a protected philosophical belief relating to gender critical beliefs. So very much watch this space. And then finally, with the All Answers case, this was simply one dealing with the duration of an impairment for disability purposes. And effectively what it says is the impairment's got to last or be likely to last for at least 12 months to constitute a disability. Now, finally, in relation to 2021, we deal with mandatory vaccinations. I'm going to deal with this in two parts because obviously there's been quite a lot that's happened in 2022. But in relation to what happened in 2021, as the first bullet point states, the backdrop to this was the government's concern that for all that there was a high take-up of the COVID vaccination programme, there was still a material cohort of the population not electing to get vaccinated, and this was reflected in the statistics from within the care home sector as with anywhere else. So the government elected to make full vaccination a condition of employment for anyone who worked or volunteered in a CQC-regulated residential care home in England, unless exempt for medical reasons, and that came into effect on the 11th of November. Now, whilst this was as far as the mandatory vaccination programme went in the public sector last year, there were employers in the private sector that were doing similar things. An example of this was London outfit Pimlico Plumbers, who you might be aware are never very far from some employment law controversy or other, which elected to introduce a much hyped no jab, no job hiring policy in 2021. This required all new employees to be fully vaccinated. The rationale behind this was that the tradesmen and women engaged by Pimlico plumbers would regularly have direct contact with, and indeed be inside the homes of any number of customers on a daily basis, and therefore at particular risk of catching and spreading the virus. Now, whilst there have not as yet been any reported cases in respect of complaints relating to no jab, no job policies, it isn't hard to foresee that such a policy would come with a material risk of claims, not least indirect discrimination claims, given the arguable disadvantage that certain groups will be put to as a consequence of factoring in disability, pregnancy, age, or indeed race, by way of example of relevant protected characteristics. When it comes to existing employees, there is a whole other dimension to consider aside from discrimination, being unfair and wrongful dismissal in the event of dismissal for failure to get vaccinated, and breach of contract. In effect, this means that employers would be unable to implement a no jab, no job requirement on their existing employees without their consent or without consultation, followed by termination and re-engagement. And this is because any such measure would represent a change to their contract of employment. So that was 2021. I'm going to move on to 2022. Jonathan, if there is any particularly pressing issues in the Q&A section from 2021, which you'd like me to deal with now would probably be an appropriate point.
Yes, thank you, Ewan. How common are contractual hybrid working arrangements now?
Well, if I can put it like this to you, that I am being asked about hybrid working arrangements by, I mean, I'd go as far as to say every other of my my corporate employer clients is wanting advice from me in relation to putting in some sort of hybrid, or at least discussing a hybrid working arrangement. Now, not all of them, it must be said, regard hybrid working as their preferred approach. Some of them do actually want all their staff to come back full time because that's the way that they think that they work most effectively, that they think that people collaborate best on certain project work and whatever else. But in terms of how common it is for employers to be considering this, I'd say it's extremely common at the moment.
Okay, all right. No, thank you for that. You also, around hybrid working, you mentioned employers maybe introducing KPIs or one-to-one reviews. I think from a one-to-one review perspective, the question raised was, how regularly should these be?
It will vary from organisation to organisation. I mean, if I can give you an example that ordinarily, I mean, I wouldn't expect for these one-to-ones to be more than maybe every fortnightly or so on. But if there's a particular source of concern about an employee's performance or productivity, then I don't see any reason why it couldn't be weekly or even more frequently than that.
Okay, thank you. And then I think there was you mentioned about data and systems being secure, with people now working from home as well as in the office. I think somebody's asked, should this information be put in the employee's handbook so that all are aware as to what is required?
Yes, I mean, that's not all of what I would recommend an employer does. There are also technical non-employment law steps involving the IT solutions, which I think are very important to trying to manage the risk associated with any data breaches or leaks of confidential information. But as a minimum, absolutely revise your existing IT policy, or indeed incorporate it within a home working or hybrid policy to ensure that people, and don't just put it in there and don't tell anyone about it, actually let people know that this has been changed so that they are absolutely aware of the critical importance of maintaining data security.
No, Ewan, thank you. That's it from me for now. Before I hand back to you, can I just remind everybody, if you've got queries, questions, if there's something wrong, please let me know via the Q&A or the chat facility. People keep raising their hands. I can't deal with raising hands on a Zoom webinar. Thanks, Ewan, and I'll hand back to you.
Thanks very much indeed, Jonathan. Now, as I say, on the screen at the moment is a summary of the key developments that we have already seen so far this year and we expect to see later in the year. A brief word of warning that the word might in the heading has been added entirely deliberately. Several of the legislative measures have been announced by the government as being introduced, quote, as soon as parliamentary time allows, and then nothing has been heard since. Accordingly, there will be a certain amount of speculation as to when the proposed legislation will be put to Parliament and whether it will be passed into law. Now, one thing, though, that we don't need to speculate on is the position in relation to mandatory vaccinations this year. On the 9th of November, following a consultation on making COVID vaccination a condition of deployment in the health and wider social care sector, the government announced its intention that from the 1st of April, vaccines would be mandatory for roles in the sector that have direct face-to-face contact with patients and service users. These regulations were debated in December and came into law on the 6th of January. Therefore, as at that point, from the 1st of April, being fully vaccinated was to be a condition of employment for anyone considered frontline staff in all CQC regulated healthcare settings. This wasn't just NHS hospitals, by the way, that was a bit of a misconception, meaning if they were not vaccinated and didn't have a medical exemption, they would not be able to work. And following that going into law, needless to say, many organisations who provided staff and workers within hospitals and other CQC regulated environments had to actually start processes of putting into place contractual variations in this respect. But of course, as most of you will know, the government subsequently amended their position on mandatory vaccinations, apparently after considering recent changes and findings in relation to COVID. So the increased vaccination numbers, the reduced severity of the Omicron variant compared to Delta. And so on the 31st of January, Sajid Javid announced the government's intention to revoke both sets of regulations, so the January ones and the ones from November in relation to care homes, subject to a 2-week statutory consultation and parliamentary approval. But whilst the fact of the consultation suggested the government has not come to a conclusion on this, actually Sajid Javid said the government have made their decision. The 2-week consultation was merely a legal requirement they must follow. It's a done deal, effectively. So the government now believes that mandatory vaccinations in the health and social care sector is not a proportionate requirement in protecting vulnerable individuals from COVID. Instead, they believe that, quote, COVID is here to stay and we should therefore work on learning to live with it. Another major factor, of course, for the U-turn by the government was the impact that the new regulations would have had on the existing NHS staffing problems. The NHS, already overburdened as it is, introducing legislation which would undoubtedly lead to falling staff numbers would have only worsened that situation. Now, you might think that the government's decision to revoke the amended regulation would impact employers that currently have or are looking to introduce a mandatory vaccination policy. How could ordinary employers suggest that mandatory vaccination should be implemented at their workplace when the government has stated that workers in the health and social care sector, which is after all the sector with the highest number of vulnerable individuals, do not themselves need this? I mean, I can certainly see the attractiveness of that argument, but in actual fact, the pros and cons of a mandatory vaccination policy probably haven't changed all that much, because the government's decision was clearly motivated at least as much by political considerations as scientific ones, and employers do still have a duty to protect the health and welfare of their staff. Now, in relation to dismissals that have already taken place because of the legal requirement that there was to be vaccinated, the government have confirmed that the policy was right at the time, and so the decision to revoke the amended regulations will not affect the validity of dismissals in, for example, care homes. The government have also stated that if an employee had been dismissed for a reason in relation to mandatory vaccinations, they could now reapply for their position if still available, but they would not have continuity of employment, meaning they would have to work for another 2 years to gain certain employment rights. And to be blunt, having spoken to a number of employers in that sector who have dismissed staff previously because of the requirement to vaccinate, they're not particularly keen to get the staff back, to be blunt. Jonathan.
Ewan, sorry, can I just come in there because obviously pertinent. I have a question and thank you for it. Hello, I work for the NHS. I checked whether the amendment has been converted into law. Has that definitely been approved as we're still in limbo?
Yes, and the answer to that is, as it stands at the moment, I can't tell you for definite. However, it would be inconceivable for that legislation not to be revoked now. And certainly all the NHS organisations I'm aware of are treating that as effectively having been passed into law, because whilst the government have said that they will consult for 2 weeks, that's purely perfunctory. And the government, along with Labour, who I think will back this, have got a sufficient majority to push this through. So I can't tell you, and I'll try and look this up after the webinar to see whether or not it absolutely has been, but I am 99% confident that if that hasn't yet been done, it will be.
Thank you. Thank you. I hope that helps Natalie as well, who asked the question. Thanks, Ewan.
No problem at all. So we're next coming on to something that we have every year, which is the increase to statutory pay obligations, which I'll trot through pretty quickly. Essentially, national minimum wage has increased. So the national living wage for those aged 23 and above is now £9.50. It's £9.18 for those 21 and 22, £6.83 for those 18 to 20, and £4.81 for apprentices other than in their first year. Statutory redundancy pay has also been increased. The week's pay is now capped at £571 per week. And the overall maximum statutory redundancy payment you can get is £17,130. Statutory sick pay has been increased to £99.35 per week, up to 28 weeks. And statutory maternity pay, paternity pay, adoption pay, shared parental pay has all gone up to the lower of £156.66 per week, or 90% of average weekly earnings, except of course for maternity pay, where in the first 6 weeks you get 90% of average weekly earnings. So moving swiftly on to workplace sexual harassment. Now, this slide does require something of a history lesson. On the 25th of July 2018, the House of Commons Women and Equalities Committee published a report entitled Sexual Harassment in the Workplace, which identified a number of shortcomings and failings in the protection from sexual harassment afforded to workers by UK legislation, and made a series of recommendations as to changes that could be made to improve the situation. In its response to the committee report, the government stated it would introduce and consult on various measures aimed at enhancing these protections. And sure enough, on the 11th of July, the Government Equality Office opened a consultation on sexual harassment, which ran until October 2019. If we fast forward to the 21st July last year, the government published its response to the consultation and pledged to introduce a duty for employers to prevent sexual harassment in the workplace as soon as parliamentary time allows. A defence would be available if the employer has taken all reasonable steps to prevent the harassment taking place. To discuss the scope for further enforcement action in sexual harassment cases by the Equality and Human Rights Commission, and ask the Commission to produce a statutory code of practice on sexual harassment in the workplace, complemented by accessible practical guidance. Introduce a duty for employers to prevent third-party harassment in the workplace, again when parliamentary time allows. And look closely at extending the time limit for bringing claims under the Equality Act, bearing in mind, though, the pressures on the employment tribunal system, and any extension will apply to claims under the Equality Act generally, not just harassment claims. So where does that leave us? Well, it seems likely that at some point this year, amending legislation will be introduced to impose a new statutory duty on employers to prevent sexual harassment in the workplace. This duty can be enforced not only by victims of harassment, but also by the Equality and Human Rights Commission, thereby taking the burden off individual employees. And it also seems likely that reinforced protections against harassment by customers, contractors, and other third parties will be introduced. And in the meantime, the Equality and Human Rights Commission has actually set out various recommendations of employers taking steps such as creating public notices, advising third parties that harassment of employees will not be tolerated, introducing express terms in their contracts with third parties to this effect, and encouraging employees to report harassment by third parties. Now, possibly the most significant change would, if the government decides to go ahead with it, be the increase to the time limits for bringing a claim to the Employment Tribunal for discrimination from 3 months to 6 months. And that short time limit is often a real barrier to claimants in my experience. Now, whilst it wouldn't be the first statutory employment claim to have a longer limitation period than 3 months, as claims for equal pay can also be brought within 6 months, one can only imagine that this would lead to claims for other or calls for other statutory claims such as unfair dismissal to also have their limitation periods extended. Now, there are, we anticipate changes coming in relation to carers' leave and flexible working. To take carers' leave, first of all, now trying to balance work commitments and caring responsibilities can be challenging, and it still remains the case that women carry the lion's share of the caring responsibilities within the family, which can have a negative impact for them at work. Accordingly, a new right to carers' leave was first proposed in the Conservative manifesto for the 2019 general election, and following consultation on the form that the right would take, it was announced on 23rd September last year that it would introduce this as a right in England, Wales and Scotland. Now, this will apparently operate to give employees an entitlement to take up to 5 days per year as unpaid leave to deal with providing care or making arrangements for the provision of care for anyone who depends on the employee because of illness or old age. And critically, this carers' leave would be a right that everybody gets from day one of their employment. This is another of the proposals where no date's been set in stone, but merely when parliamentary time allows. In terms of flexible working, on the 23rd of September, the Department for Business, Energy and Industrial Strategy published a consultation document entitled Making Flexible Working the, quote, default, which proposed various reforms to the current right to request flexible working. This closed in December. And that consultation had its origins in another Conservative manifesto pledge to encourage flexible working, but it definitely rose up the priority list as a consequence of the pandemic and so many employees up and down the country working remotely for the first time, as I mentioned. Now, whilst you might reasonably think that the repeated use of the word default next to flexible working suggested that the government intended to give an automatic right to employees to work flexibly, whatever that means, which would be both revolutionary and potentially incredibly difficult to manage in practice. But what appears to be the case from the consultation is that this is not so. Instead, the government is merely seeking to rebalance the current framework so that it better supports a wider discussion of what may be possible in regards to flexible working, rather than the current focus of what is not possible. So the 5 proposals consulted on were to, firstly, make the right to request flexible working a day one right. Secondly, make changes if necessary to the 8 statutorily approved business reasons for refusing a request to work flexibly. Third, require the employer to suggest alternatives to the arrangements suggested by the employee. Fourth, change the administrative process underpinning the right to request flexible working. And finally, raise awareness of the existing right of employees to request a temporary flexible working arrangement. Once again, there aren't any specifics as to when these reforms will be introduced, but it seems likely to coincide with the employment bill. Now, the law currently states that a woman who is pregnant or on maternity leave has enhanced protections from the date the pregnancy begins to either the date she returns from maternity leave or if she's entitled, the date that she returns from maternity leave if she's entitled to statutory maternity leave, or 2 weeks after birth if she is not. This is known as the protected period. Now, during maternity leave, as well as being protected from being treated unfavourably because of their pregnancy or the fact of their maternity leave, employees have enhanced rights when it comes to redundancy. Specifically, before a woman on maternity leave is made redundant, she's entitled to be offered a suitable alternative vacancy, where one's available, to start immediately after her existing contract ends. Notwithstanding this protection, surveys in 2018 revealed that 96% of women felt that their careers were adversely affected because they'd had children. So in 2019, the government announced another consultation, and this recommended extending the enhanced redundancy protection so that it covers the period between when the woman first informs her employer of her pregnancy to 6 months after her return to work. And this is another reform which is likely to be enacted in or at the same time as the Employment Bill. Which brings us neatly on to the much discussed Employment Bill. First mooted in 2019 within the Queen's Speech, and seemingly intended to alleviate workers' fears that their rights might be diluted once the UK left the EU, as well as the aforementioned changes relating to maternity protection, carers' leave and flexible working. The bill's also supposedly going to address the following: the introduction of a single labour enforcement agency to better protect the rights of vulnerable workers and support business compliance, the requirement that employers pass on all tips and service charges to workers, and the right to request a more predictable contract if you are, for example, a 0 hours contract worker and have worked for the same employer for 26 weeks. And on 23rd March 2011, the government announced that the Employment Bill would not be introduced in this parliamentary session, but would be introduced, wait for it, when parliamentary time allows. Now, onto a slightly more light-hearted subject. To mark the Queen's Jubilee in 2022, the UK is going to be given an additional bank holiday on Friday, the 3rd of June. And the spring bank holiday at the end of May will also be moved to Thursday, the 2nd of June, to allow an extra long weekend. Employees are not going to be automatically entitled to this extra bank holiday if their contract states that they are entitled to a certain global amount of holidays per year, which include bank holidays. However, if the contract states that they are entitled to a certain number of holidays each year in addition to bank holidays, then they may arguably have this entitlement, unless the contract specifically lists which bank holidays the employee is entitled to, or refers to the normal bank holidays in England, Wales, Scotland, and Northern Ireland. Now, truth be told, I suspect that irrespective of what the contract says, many employers will allow employees to take this as a goodwill gesture to maintain staff morale. If an employer does need employees to work on 3rd of June and their contracts entitle them to take this off, then, needless to say, the employer may wish to consider offering enhanced pay, time and a half perhaps, and or a day off in lieu to incentivize the employees to work on those days. Finally, a few more cases just to update you about. These are cases that either have already gone for appeal this year or are due to. The first is the case of Harper against Brazil. This was a case where the claimant was a teacher who only worked term time under a 0 hours contract, claimed that her holiday pay was calculated wrongly by the school. Now, the school had calculated her holiday as 12.07%, which is a figure I'm sure many of you will be familiar with, of hours worked in a term, whereas the claimant said it should have been done on an average of the 12 weeks before she went on holiday. And the Employment Tribunal found in favour of the school, but both the EAT and the Court of Appeal said her holiday pay should have been calculated as she had contended. Notwithstanding that this arguably led to a slightly more favourable financial outcome for the claimant than it would do for a full-time employee. The Supreme Court hearing took place on the 9th of November, and the judgment is expected this year. Now, this will, needless to say, be of particular interest to schools and other business that operate in term time, but not exclusively of interest to those kind of businesses. The next case is that of Chell against Tarmac Cement and Lime Limited. In this case, first the County Court and then earlier this year, the Court of Appeal ruled that the respondent was not vicariously liable for injuries suffered by the claimant, who was a contractor because of a practical joke another employee played on him. The what I can only describe as hilarious practical joke in question was the detonation of 2 explosive pellets close to the claimant contractor by an employee of Tarmac Cement, which caused a perforated right eardrum, noise-induced hearing loss, and tinnitus. As I say, hilarious. The County Court said that it was too much to expect an employer to put in place policies to try and reduce the amount of horseplay or the playing of practical jokes in the workplace. And there was insufficient connection between the position in which the employee was employed and the wrongful conduct to make the employer vicariously liable, and the Court of Appeal has now supported that position. And finally, we've got another case involving Pimlico plumbers. Mr. Smith had initially succeeded in persuading the Supreme Court that he was a worker and not self-employed. Fantastic. Before then having his claim for holiday pay during his employment ignominiously dismissed by the Employment Tribunal for having been brought out of time. His subsequent appeal to the AT, arguing that he should have been entitled to carry over his leave from one holiday year to another, much like the situation in the case of King against Sash Windows, was also unsuccessful. The AT said that he would only have been entitled to carry over accrued but untaken holiday, and in Mr. Smith's case, he'd been allowed to take holiday, but he just hadn't been paid for it. Now, if that seems incredibly unfair to you, don't worry, because the Court of Appeal have now overturned the decision to the tribunal in the AT, holding that his claims for holiday pay were actually in time, and the tribunal had erred in law by deciding otherwise. Mr. Smith had been denied the opportunity to be paid paid for annual leave throughout his employment with Pimlico, and it was unnecessary for him to specify whether the leave was untaken or taken but unpaid. It simply came to the same thing. So we have covered a lot of ground today, and this was necessarily a canter through the issues. So I envisage we might have a few further questions. We've certainly got at least 9 minutes in which to deal with any of them. Jonathan, over to you.
Yeah, no, thank you, Ewan. Yes, you have. We've provided a very useful and a very thorough update with a lot of information covered. First question. Thank you, Wendy. Do you think long COVID will be considered a disability in the future?
A great question and very topical indeed. I think it is possible, the more we find out about long COVID and the symptoms of long COVID and the length and likely duration of long COVID, I think the more we will know about whether it ticks off the boxes to class as a disability for the purpose of the Equality Act. So I think that it will depend a lot on the medical evidence that comes out in the months and the years to come about what the impact that long COVID has on people who suffer from it, and what that time frame is. But fundamentally, in any given case, it is arguable if the person suffering from long COVID has symptoms which have a significant impact on their ability to conduct day-to-day affairs, and those are likely to last for a year or more, it ticks off the boxes.
Okay, thank you for that. I've got one related to paternity pay, paternity leave, and I'll read the sort of the question and the example as it's put. Thank you, Syed. One of my clients said they have been working for a company and she has requested to the company to apply paternity holiday, but the company do not appear to be serious, and now the company have said it's too late to apply. So the question really is, so can my client get paternity holidays as the baby was born on the 15th of February this year?
I see. So this is presumably a question about when paternity leave can be taken. I mean, I would have thought, and again, that's a situation that I might want to speak to your member separately to get the detail of this. But fundamentally, any employee who is a father or who otherwise ticks off the necessary criteria to qualify for paternity leave is entitled to take paternity leave. Now, if they have been essentially deprived of being able to take that contemporaneously because of the employer, it would seem to me to be, I mean, the spirit of the paternity leave rules would surely say that they're entitled to be able to take it at a later point. But that is something I probably would want to pick up separately with that member, and I'm more than happy to take a separate call from them about that.
Okay, Said, can I make the suggestion? You'll see on the screen in front of you that you've got Ewan's email address and telephone numbers. Can I suggest you pick up with him offline outside of the webinar today? But thank you. Ewan, you mentioned, I think, a number of slides back about national minimum wage. I've got a question there sort of saying, can you just repeat what the national minimum wages are at present?
Well, I mean, what I suppose I went through was what they will be in April. So again, I could follow up with what they currently are, if that would be helpful at the moment. They are freely available on, I think it's .gov.uk has got all the details about the relevant national living wage and national minimum wage, and the rate of statutory sick pay and so on. Yeah. But happy to signpost if that would be helpful.
Okay, thank you. Brilliant. Thank you very much indeed for that. Syed, I think you've kindly provided your details. My suggestion was, can you make contact with Ewan outside of the session today? So that's brilliant. Thank you. Ewan, I'm not surprised. I've got a lot of people commenting saying many thanks, excellent presentation, very helpful, very useful. So maybe on behalf of members, can I thank them for your time, your energy and your efforts. I'm just checking the Q&A box again before I move us on. I'm getting a number of questions. Firstly, today's session and these sorts of webinars that are hosted by the Institute are classed as verifiable CPD. So to the 2 or 3 members who have posed those questions, yes, it is verifiable CPD. Secondly, I'm also being asked, will the slides be made available? And I think you kindly said at the beginning, and you also confirmed with me yesterday that we could share the slides. We will do so. And to those of you who've asked for a recording of the session, when we send the slides in the next 24, 48 hours, we will send a recording of the session. So I hope and believe that I'm covering off quite a few of the latter questions from members. And that's probably pertinent for people who regrettably have had some internet connectivity issues. You should be able to pick everything up from the recording that we send through. I'll just look one more time. I think everybody is just thanking you, Ewan. So they're doing my job in a way for me. So Ewan, thank you. Much appreciated for you joining us this afternoon, and the detail and the practical nature of the detail that you've given. Much appreciated. I always like the case studies because I just think it brings a subject matter to life. So much appreciated for those as well.
You're very welcome.
Thank you. Before I draw the session to a close, and I think I'm going to manage to do that pretty much on time, can I just remind everybody of where you find the continual update of the Institute's CPD and events programme? It is all on the website. And when you visit the website, www.ifa.org.uk, there is a separate tab headed up CPD. That's where you will find a listing of everything, whether it be online or face-to-face events that we are offering in the weeks ahead and in the months ahead. Can I just draw to everybody's attention a few things before we close? One, with the return, we hope, to normality, we will be holding face-to-face regional conferences this year. So for those of you who haven't yet registered, London is on the 26th of May, Birmingham is on the 23rd of June. A couple of ones to watch from a webinar perspective. There is the first quarterly financial reporting update on the 24th of March. The agenda for that update is on the website underneath that particular heading. We've just promoted for the 30th of March an annual payroll update for 2022. As I say, that will take place on the 30th of March. We will continue with what we're calling the IFA 60-minute webinars. So whether they are UK or internationally focused, there are a number of those that will occur on a monthly basis. Topics coming up: intellectual property, cybersecurity awareness, grants, sustainability and SMEs, and enterprise risk management, just to give you a feel and a flavour. Finally, from myself, we are also starting regional face-to-face networking events. The first is being held in the north on the 24th of March. Details are on the website. I have a date for Scotland, which is just looking down at my notes, which is the 28th of April. Further information around that will follow. And our other regions are working behind the scenes on dates and venues for other face-to-face networking events. We do hope members will be keen and able to attend both face-to-face and online events moving forward. So enough from me. I've brought us, I think, together on time. Again, Ewan, many thanks for your time this afternoon. Very useful, very practical, very worthwhile session. So on behalf of everybody who hasn't already thanked you, thank you. To members who've joined us, thank you very much indeed for doing so. As a reminder, it's your responsibility to update your CPD records via your CPD dashboard on the Institute's website. We look forward to seeing everybody again very soon online, and soon in the couple of weeks ahead at face-to-face events. For the rest of you, thank you very much. Have a good afternoon, and Ewan, once again, much appreciated. Thank you. Cheerio to all.